And joining me now, we have MSNBC legal analyst and former New York prosecutor Charles Coleman. And then here with me in studio, we have Richard Pildes, a constitutional law professor at NYU. He has argued voting rights cases before the Supreme Court, which means, as I thank you both for being here, we are starting with you, Richard. So let's take a listen to a little bit of what we have just heard. Well, we actually don't have that. But the group that is bringing this map justification, this challenge here, walk us through the issues at the center of this case and why this group is bringing this challenge.
So Louisiana has 6 congressional districts. It has a black population of about a third. It has had for a while now 1 congressional district that has a majority of black voters and has been electing a black representative to Congress. Initially, litigation was brought arguing that the state has an obligation to create a second Voting Rights Act district.
Okay, and just as I said, we didn't have that soundbite popped up. Let's take a listen to them, explain what they're doing, and you can elaborate on the other side. So here it is, everybody.
My humble point is that the government has no business telling citizens in which districts they may live or what voting power they may
exercise. But it's not doing that, counsel. The 6 plaintiffs in this case are white plaintiffs who live in a district with black voters. So no one's keeping them out of that district. No one's stopping them from participating in the voting process. No one is stopping them from trying to run candidates or support candidates that reflect their views.
What's the purpose of that kind of district? The avowed purpose of drawing a majority black district is to diminish the voting strength of some racial groups and augment the voting strength of others.
Interesting point that Justice Sotomayor makes, that this has been brought by a group of white voters that live in a black district.
Yes, they're arguing, and there is Supreme Court doctrine behind this, that this is an unconstitutional racial gerrymander, the creation of this second black majority district, which was done pursuant to a federal court order and a decision that the existing Louisiana map discriminated against black voters by not creating a second majority black district. That district was then created. Now, it was actually created by the Republican legislature in a partisan way for their own purposes. And then these voters brought the challenge saying what Louisiana has done is an unconstitutional racial gerrymander. So they're actually challenging a Republican-generated map, but a map that they were forced to create by the federal courts, holding that the Voting Rights Act would be violated if they didn't create this second black majority district.
And again, you say that in totality, about 1/3 of the residents in the state are black.
Yes.
You have 6 congressional districts, of which now 2 are represented in black communities with black members in Congress. So that seems pretty representative, right? I mean, it seems pretty fair.
That's correct as far as it goes. The doctrine in this area for a long time has been very complex. So the court has said states have obligations under the Voting Rights Act not to discriminate in the way they draw districts, but they also can't use race in a way that is excessive, according to the court. And so it's the intersection of these 2 forces that are kind of at the heart of this case. The court could decide this on very narrow grounds. It was interesting listening to the argument that a number of the conservative justices actually offered very narrow grounds to decide the case, or the court could decide this on much more expansive grounds.
So, Charles, let's play some of what we heard from the NAACP, this on the impact of throwing out the map in Louisiana. Take a listen.
Were Section 2 to cease to operate in the way that you just described, what could happen? What would the results on the ground be?
I think the results would be pretty catastrophic. If we take Louisiana as one example, every congressional member who is black was elected from a VRA opportunity district. We only have the diversity that we see across the South, for example, because of litigation that forced the creation of opportunity districts under the Voting Rights Act. Every justice in Louisiana has been elected through a VRA opportunity district, and nearly all legislative representatives.
Let's expand this. Help us understand the stakes as they extend beyond Louisiana.
Well, Alex, this could not come at a more important time when you're thinking about the way that the VRA has been basically on open season, as well as there's been continued attacks on the right to vote for underrepresented communities. When you look at Texas, for example, recall that the recent standoff in the state house was primarily about the gerrymandering that this map electorally had been going through with respect to its legislature and how the state had been carved up. When you're thinking about midterms, the implications of this case, Alex, are huge, because ultimately, if the Supreme Court allows state legislatures to carve up maps without any regard for race, or does not narrowly tailor the specifications as to when and how race can be used, this would basically propel all of the redistricting and gerrymandering efforts that we've seen going on across the country. And it would also set up a model where, regardless of who is in the majority in state houses, we would continue to see this over and over and over again every time that a new majority took its place in a state legislature. So from a timing perspective and from an impact perspective, the implications of this case are significant when it comes to our future elections.
And Charles, the Supreme Court has taken somewhat of a colorblind approach to the Constitution in terms of what we saw in the 2023 affirmative action case. What do you expect this time?
Well, there's truth to that, Alex, but then there isn't. In as much as the Supreme Court has played fast and loose when it wants to be colorblind and when it doesn't. So, for example, think about the decision around allowing, at least for the moment, ICE to move forward and consider race and racial implications as a factor. So the Supreme Court decides when and when they don't want to use race. I think that in this case, I'm hoping that we will see that prevail in understanding that this needs to remain intact. Section 2 needs to remain as a premise that goes forward. But with what we've seen from Justice Roberts, some of the commentary and framing that he's done in past opinions, particularly in Shelby versus Holder, where he talked about the need for these sorts of racial discrimination, prevention methods not being necessary, I think that it's going to be a very, very tall hill to climb.
Okay, Charles Coleman. Richard, thank you so much. Richard Pildes, appreciate you both.